Health, Ethics, and Law, an international radio program produced by the World Association for Medical Law. Editing and broadcasting by Oren Asman.
Hello and welcome to another program on health, ethics, and law. We are broadcasting from the annual meeting of the American College of Legal Medicine in Orlando, Florida. With me today is Professor Cyril H. Wecht, a physician and an attorney specializing in pathology, past president of the American College of Legal Medicine, past president of the American Academy of Forensic Sciences, and a very prolific researcher and writer. Professor Wecht, you're both a doctor of medicine and a doctor of law, is that right?
Yes. Well, it's called Juris Doctor, yes. It's not the same as a PhD. They used to refer to them as LLBs, Bachelor of Laws, and then the lawyers in America said, hey, if we go 3 difficult years, why should we be called a bachelor? We want to be called doctors too. So they came up with the JD degree, which is a degree that law schools in the United States of America now confer upon their graduates.
What attracts a person to do dual degrees like that?
Well, in the United States, perhaps more so than any other country, but certainly not to suggest that we don't find these things in other countries, but in our country, we have a greater degree of litigation in many fields, especially in the civil law. For example, medical malpractice. In many countries, you won't find medical malpractice lawsuits. In other countries, to a very limited extent, and with onerous burdens placed upon the plaintiffs who wish to pursue the cases, putting up large sums of money, so to speak, in case they lose the case, then they have to pay that money to the defendant doctor and so on. In the United States of America, where we have a contingency fee, you don't have to pay the lawyer, and you don't have to put up any money, so people sue physicians, and I think properly so, where they have been injured or sometimes where people have died. So we have that, and in the civil area we also have a tremendous amount of product liability litigation brought against companies of all kinds, automobile manufacturers, pharmaceutical manufacturers, wrongful death actions of all kinds, insurance policy claims, all kinds of accidents, home falls and falls in the street, industrial accidents, and so on. And then in the area of criminality, we also have a large involvement of people in legal medicine and forensic sciences. As I say, you'll find these things in other countries, but for better or worse, and that's a subject for another day. Is it good to have these, or is it too contentious for a society to be so involved with these kinds of lawsuits? Yes. But let's simply say at this time that we do have all of this. Now, in addition to the things I mentioned, we have a whole vast area of what is referred to more broadly as health law. All the things having to do with the obligations of physicians under Medicare and Medicaid, all the federal legislation that tells physicians and hospitals to do this or not to do that. These are all things that medical legal experts address and deal with.
So you're talking about health law. Is that a sort of a translation of the ethical codes to laws?
Well, ethical codes indeed are part of this entire field, but ethics does not cover all of these. While one can talk philosophically, societally about the ethical ramifications of all these kinds of litigations, when we talk about medical ethics, we're not talking about that. We're talking about ethical conduct by a professional person, physician, other people in the healthcare field, and so on. Yes. How do you treat people? How do you deal with them? And then you get into a lot of ethical questions too. In the United States, right to die, physician-assisted suicide, and all of these questions, withholding of medical treatment, etc., medical care in an emergency room setting, and etc. So these things do have many, many ethical questions. But medical ethics is a part of the overall field of legal medicine. It is not synonymous with legal medicine.
All right. So you mentioned a lot of lawsuits where it seems that there are a lot of legal but also medical questions that are involved. So that would probably call for some medical expertise to decide on the case. Now, judges are usually not doctors, I would assume.
That's an excellent point. Not only are judges not doctors, but in the United States, and I can only speak of my country, I have some knowledge. I've testified in other countries, including Israel. And I have a little knowledge of the judicial systems. But in our country, not only are judges not physicians, which is understandable, but to a great extent, overwhelmingly and quite regrettably, they're not trained in science. Because in the United States, the students in college and universities who are pre-law and thinking of law school,
Yes.
90% of them do not like science.
Yeah, it seems
They
like
have
a
certain,
waste of time,
certain,
right?
well, not a waste of time, but they're onerous academic burdens. They don't want to take physics and chemistry and biology and zoology and so on, and they avoid them. Now, those pre-law students then, with no scientific training, go into law school. And in 3 years of law school, they don't get any scientific training. Some law schools in the United States now have a course in legal medicine. I teach such a course at Duquesne University School of Law in Pittsburgh. Many law schools have one course. Many law schools have no courses. So they come out after 3-4 years of law school, and they have even a diminished amount of involvement with science, so to speak. And now from that group of lawyers, eventually will come our judges. And now here is the paradox. These are the people then who are sitting in judgment about the credentials, about the expertise, about the validity of that particular science to which a physician is testifying. Isn't that absurd?
I don't know. You tell me. Because when I think about it, if I have a problem that has to do with construction, then I perhaps go to the court who doesn't have the knowledge in construction, and it has to do with another professional issue, then the court doesn't have all the accreditation in all fields.
That's right.
So what do we do?
Well, that's a real problem, and I'm fascinated by your focusing upon this, because many people fail to pick this up. The answer that you would get, I think, from most legal scholars in the United States under our Anglo-Saxon system of justice, which to a great extent I do believe you have in Israel because of the British involvement over the years, the answer would be that the judges are learned people. They are there to see to it that the laws of that particular nation are followed, the constitutional, common law, court decisions, and so on. And in our country, of course, we have, to a much greater extent than you will find in any other nation of the world, juries. In many countries, there are juries for criminal cases, but not in civil cases. In our country, all these civil cases, which I referred to before, medical malpractice, product liability, wrongful death, insurance policy claims, etc., there will be juries. Now, here's another interesting paradox. 12 people picked up from all walks of life. This one is an elevator operator. This one's a truck driver. This one may be a school teacher, whatever. And now their collective wisdom is going to result in justice. But the amazing thing is, study after study has shown, when they have compared the decisions of juries in these cases to the decisions that the judges would have made had they been sitting alone, they have found very, very close numbers, a divergence of only a few percentage points. So it is amazing that somehow these 12 non-scientific, non-trained, and to a great extent uneducated in terms of advanced education and so on, that somehow collectively, after hearing the witnesses in a case and so on, and applying the law as laid out by the judge, they do come up with what judges and then legal scholars in reviewing the cases later on, objectively, with no involvement or bias in the case, conclude that they would have come up with also. So somehow it works.
And if it works, some would say, if something works, don't touch it, leave it the way it is. Now, this leads me to a question. You have been yourself serving as an expert,
To a great extent. I've been doing this since 1962. So for 48 years, I've been an expert. I would say that I've testified in well over 1,000 cases.
Wow.
Civil, criminal, workers' compensation. That's a whole other big area in the United States of America. Under our laws, the person who is injured on the job
Yes.
Can sue, and he doesn't have the same burden in terms of proving in negligence. He just has to show an injury and causation. And sometimes for me, then as a forensic pathologist, that relates to my autopsies. What do I find at autopsy? I do, for example, cases in which retired coal miners die, and under the laws of our state, Pennsylvania, where I am, you have to show that the person had chronic obstructive pulmonary disease, coal workers pneumoconiosis, also called black lung disease in our country, and that it was a substantial contributing factor to his death.
Okay.
So I do the autopsy, and then I testify. Asbestosis cases, I've been involved in a lot of those. And then, of course, most of the cases I am involved in are homicides on the criminal side and medical malpractice on the civil side.
Right. So let's say you are called to testify on a malpractice suit as a doctor, right? So what would you be
in my
asked?
field, yes.
In your field. So your field is
pathology.
Pathology. So what would be a relevant case? Give us an example.
Well, all right, I'll give you an example. Let us say that a patient comes in and has abdominal surgery, and complications develop following removal of a tumor in the bowel or removal of the gallbladder, something like that. And then the patient develops problems and complications, lingers for several days or a week or two, and then dies. So on the one hand, the attorney now representing the family in that case has to prove that there was negligence, that the doctor did something wrong, maybe nicked the bowel, which led to peritonitis, inflammation of the abdominal cavity, or maybe nicked the common bowel duct, which caused some kind of inflammation and later infection. And that will fall into the purview of another general surgeon who will testify as to the standard of care. That surgeon will say that that should not have happened. I'm not a surgeon. I don't address that, and I'm not going to express an opinion on standard of care. But now the defendant doctor, his attorneys, the insurance company say, well, that may be, but that's not really what caused the patient's death. The patient died because he had pre-existing heart disease, he had pre-existing kidney disease, and those problems developed, and that really is what resulted in the death.
I see. So
I come in as a pathologist, and on either side, depending on what I find and who's consulted me, to establish the direct causal relationship between the alleged negligence and the death.
Now, there's quite a lot of money involved, isn't it so?
Oh, there's a lot of money involved in these cases because you can have quite large awards. But keep in mind that 40%, which is what the attorneys make on a contingency fee, in some states less, and some states have a sliding scale, maybe 40% of the first 5,000, then down to 33%, and down to 25%.
Isn't it up to the choice of the lawyer? Is it?
No, to some extent it is, but in some states like Connecticut, they have a law, and in those states, and as a matter of ethical universal propriety, you'll not find more than 40% contingency fee. But the point I always make is, remember, 40% of zero is zero.
Right.
So a lawyer, if you take cases that are bad cases because you're looking at a pot of gold at the end of the rainbow, and you have to spend tens of thousands of dollars to review the case and have it analyzed by experts, pay for their testimony and so on, you're going to be out of pocket $50,000, $100,000 in those special fees very quickly. And if you do a few of those in bad cases, you know what? After a year or two, you're out of business. Yes.
Right. So the lawyer can get contingency fee, and he's going to work very hard to win the case.
Exactly.
This actually, presents us with another question. If you know that losing the case will, cost you a lot of money, I don't know, it may make you want to prove something that probably sometimes maybe isn't there.
Well, I have no doubt that sometimes a plaintiff may undertake such an endeavor. But as I've already pointed out, in the United States, you cannot even get into the courtroom unless you have now a preliminary opinion from a physician that it is a bona fide case, that it's meritorious. That opinion doesn't necessarily have to come from the doctor who will testify, but it has to be the opening gambit. It has to be something to show the court that it is not a frivolous matter. And then, as I've already said, in the United States, the overwhelming percentage of cases come out in favor of physicians. Because in our country, physicians rank highest in every poll that is ever taken among groups of people who are respected. Usually Supreme Court justices, judges, and physicians will be second, or sometimes physicians will be first. Yes. Lawyers are usually ranked, way down at the bottom. And so really it's funny in a way, but the point I'm making is that the lawyer does not begin the case with some kind of inherent societal advantage, quite to the contrary. So no, lawyers who pursue these cases that do not have a solid basis are in trouble. And remember this too, that if there is no solid basis, you're going to have a difficult time in finding an expert.
Are you going to have a difficult time?
Oh yes. There are experts nowadays. 50 years ago and 40 years ago, there were people who you could say were medical prostitutes. They went around, they testified here, they testified there. As a result of case law in all jurisdictions, now I can say unequivocally that a doctor will not be permitted to testify in a malpractice case unless he or she has expertise in that particular field. And you can't come in now then, even let's say as a skilled general surgeon, and testify about thoracic or cardiovascular surgery.
Yeah, and if you do that, you're going to harm the case, right?
Well, no. The judge won't let you. The judge won't let you.
And does the judge understand which kind of specialty is needed?
The judge then is educated by the attorneys. He's presented with information. What is that particular specialty, and so on. And, in fairness to the judges, while I've said that they're not scientists, they are educated people. And the overwhelming majority are, basically intelligent. And the overwhelming majority want to do an honest, objective job. And so they review the facts and the information. And to a great extent, as I've said, they are also bound now by statutory law. All states, pretty much, have adopted certain rules and regulations about expert testimony. And so therefore, the idea of pursuing frivolous lawsuits is really one that does not play out. And the other thing that I should mention is that there's a common belief still extant that doctors right away will cave in. And their insurance carriers say, okay, here's $5,000, here's $10,000, go away. No, I can tell you firsthand that is not the case. They will fight these cases tooth and nail, even where they know they're going to pay. Why?
To pay less?
No. You know why? They got everything in the world going for them. Number one, you, the plaintiff, you may die, or if you're already dead, the members of your family may die. They may be hard up and pressed for cash. They need money. Everything in the world is going for them, whereas the Holy Grail insurance company, the defendant, they're going to be in business forever. They set aside $100,000, which they calculate based upon their analysis of the case as the amount of money that is likely to be awarded. They invest that $100,000, build another structure in New York City, or invest the money somewhere in gold or on the market. And 3, 4, 5 years later, by the time the case comes to trial, and they settled it on the eve of trial, they've already made back their investment, maybe half or sometimes as much as that $100,000. So they're really paying nothing. So these insurance companies are not at all in a hurry to pay money, even in the most egregious cases. The most egregious cases, like what we call res ipsa loquitur, the thing speaks for itself.
Yes.
Taking off the wrong leg, operating on the wrong side of the brain. You would think, my God, don't you want to settle that case and get it over with tomorrow, next week, next month? And the other thing to keep in mind, too, is that I mentioned the plaintiff's attorneys are working on a contingency fee.
Yes.
They'll get money only if and when money is obtained by settlement or by trial. The defense attorneys, on the other hand, are making money by the hour.
Retainer,
they charge by the hour.
Yeah.
Well, a retainer, but by the hour. If they settle the case in a day, a week, a month, how many hours? But if the case goes on and on and on, then the hours build up. And at $400, $500, $600, $700 an hour, which is what these good attorneys charge, you see, they're not going to be in a hurry either to settle the case.
Health, Ethics, and Law, an international educational initiative of the World Association for Medical Law.
So let's talk about ethics. It calls for a little discussion on ethics, both ethics, medical ethics, and both ethics of the lawyers. Because let's say I'm a lawyer and I get money by the hour. Isn't it my ethical obligation to do the best I can to get the best, legal representation to my client? Once I'm done, I'm going to go to the next client. If I'm a good lawyer, I don't need to make those cases long.
Yes, everything that you said is honest, honorable, just, logical, and ethical. But it doesn't work out that way. It doesn't work out that way. I don't want to condemn all defense attorneys, but I'm telling you the way things work in the United States, and I speak with knowledge and experience. And I'm telling you that, and I'll repeat, that even the most unequivocal, egregious cases do not settle quickly because the insurance companies are in no hurry to pay. They take the money, so to speak, figuratively from account A, and they place it over in account B after they've analyzed the case and determined that it is likely to result in a cost to them of $1 million. They take that $1 million and it's working for them. And the defense attorney is in no hurry. And in fairness to them, there are things that they want to check out. So they get their own experts to review things and so on. You can say that, but there's no doubt in my mind that there are many cases that could and should be settled promptly if you look at it strictly from an ethical standpoint in terms of professional responsibility and setting aside who's making money and so on. Why don't you settle this case where it's clear that somebody really messed up? Why don't you just settle and get it done with? But it doesn't happen in the United States.
So let's say you're a surgeon. You made a mistake. And you feel that it was wrong and you should pay for it. You go to your insurance company and say, listen, I made a mistake. Please pay. And they say, be quiet. Is that what you're saying?
You, the doctor, cannot make the insurance company pay in the United States. You can go and say that, the hypothetical that you have just set forth, but it has no legal authority whatsoever. You cannot make the insurance company pay. And turning that coin over, you cannot prevent the insurance company either from settling the case in the United States now.
Okay.
If they say no, you, the doctor, you want to get out of it. It's bothering you psychologically. You're tormented. It's eating you up alive, and so on. And you say, please pay this, get rid of them, and so on and so forth. The insurance company says, no, we feel we have a justifiable defense here, and we're not going to settle. We're certainly not going to settle now. And I'm sorry, doctor, you're just going to have to live through this mental anguish. Then they're in charge.
Mm-hmm. So we're talking about a bit about ethics, and I was wondering about the ethics of the expert witness, because it seems a different story. When you're the treating physician, you have a certain relationship with the patient that you're, treating. But when you're an expert witness, so you're called to examine perhaps a living person.
That's right. Some doctors will be called to examine.
But he's not your patient, is he?
But no, he's not. No, there's no physician-patient relationship. You're quite right. But there's nothing unethical about this. The only thing that is unethical is if you, called upon as an expert consultant, come up with an opinion that is tailored toward the side that has retained you because you're making money, and you'll make more money by being called later on and being paid for your deposition and to testify in court and so on. That is unethical, irresponsible, and from my standpoint also, I think it's illegal. It's immoral and rotten, and if you could prove it, it's something that could be pursued. But of course, how do you prove these things? Now, bias, as we all know, is something that is conscious and subconscious. And to the extent that it is conscious, then it is to be condemned. And to the extent that it is subconscious, who knows how to deal with this? What we see in the United States of America, to a very great extent, is that many experts will only testify for one side or the other. I'm proud of the fact that I don't limit myself to one side or the other.
You mean either the defendants?
Yeah, not in the same case, of course.
No,
I can't be on both
course.
sides. But I testify. For example, I do autopsies for coroners in 4 counties outside of my own county. I live in Pittsburgh, Pennsylvania, and I do over 300 coroners cases. And in those cases in which the person is charged with homicide, I will then testify for the district attorney because I have called it a homicide, and that's why the case is being pursued in that fashion. On the other hand, in other jurisdictions, I am called upon more frequently by the defense because in other jurisdictions, they have their forensic pathologist who did the autopsy.
Right.
And that's why they're pursuing the homicide case in Kansas City or Houston, Texas, or Detroit, Michigan. And they need, the defense needs their expert. And so they turn to people like me.
So basically you're helping the court or the jury?
Well, you can say I'm helping the court, I'm helping the jury, I'm helping the pursuit of justice. Sure, if you want to wave those flags, I'm not sitting here and telling you that I'm on some God-given mission, but I can honestly say that I call the cases as I see them. And of course, look, remember this. Medicine is not an absolute science.
Right.
It's not physics, chemistry, mathematics, astronomy. And we know that. You see that every day in the lives of your neighbors and friends and families. You go to a doctor and he tells you need your gallbladder removed. And you go to another doctor and he says, nah, just watch what you eat, you'll be okay. You go to this doctor and he says, you should have a stent put in your coronary artery. The other doctor says, nah, we'll watch it for a while, just lose some weight and cut down your cholesterol and you'll be okay. Now, do you have differences of opinion there? You sure do. Well, why is it that in the medical legal arena, when a second doctor gives a different opinion, then some people right away say, oh, he's a medical whore, he's a prostitute, his services have been bought, and so on. There are differences of opinion.
Right.
Even I, as a forensic pathologist, with the body on the table, cutting up, dissecting, looking at tissues in the microscope, getting back reports from bacteriology and toxicology, there can be differences of opinion.
Right.
And look at cases in which I've been involved over the years that I've written about in my books. John F. Kennedy assassination, Robert F. Kennedy assassination, Mary Jo Kopechne, the Ted Kennedy case, O.J. Simpson, John Benet Ramsey, Waco Branch Davidian fire, Elvis Presley, recently John Benet Ramsey, Scott Peterson, Drew Peterson. These are cases in which there are differences of opinion, quite legitimately, on medical issues. So the point is that consultants in our system of justice are needed. Without consultants who are available to testify if they feel that they have something to offer, then justice cannot be acquired. It simply will not happen.
Yes. Well, you mentioned unconscious bias that may happen sometimes.
Don't we all have unconscious biases?
No. So for instance, is it possible for a forensic expert to get a contingency fee, because that would actually
that's a very good question.
Win the case.
Excellent question. I never have worked for an attorney in a case based upon a contingency fee. Sometimes in the past it have been offered or so on. No, that is, by the way, unethical and not permitted. As a physician, we are not permitted to work on a contingency fee. Attorneys in the United States of America ethically are. Under the Code of Ethics of the American Bar Association,
yes,
contingency fees are perfectly ethical and acceptable. in medicine, you cannot have a contingency fee. Whether it's you as a treating doctor, well, if you get better, Mrs. Ginsburg, you'll pay me double. If you die, your husband doesn't have to pay me anything. It doesn't work that way.
Right.
Or as a consultant, as a medical person, if we win the case, you'll pay me X dollars. If you lose the case, you'll pay me Y dollars. No, you are not permitted to do that, and I do not do that.
Okay, so let's say you go to court and you hear or listen to the expert opinion of another physician, and it seems to you that it's a little bit more than just disagreement on the
That he's gone too far.
It seems as if it's a little bit
Yes,
off the chart.
Exaggerated off the chart.
I mean,
what do you do?
What do you do? You say, listen, he's lying, or you say something here is. I mean, how do you?
Well,
act?
well, that's an excellent question too. And what I would do is just point all of these things out to the attorney who is consulting me, and give him questions, suggest questions that he can ask me. I'm not going to go running to the judge or submit a report to that doctor's professional organization or the hospital with which he or she is affiliated and file a complaint. And nobody appointed me as an enforcer or so, and that's not my role. Mm-hmm. But I will definitely point this out. But I will not use the term liar or prevaricator on the witness stand. I'll simply say I disagree. Now, some of my colleagues, I think, go too far and become too adamant. And for example, they'll use terms like absolutely certain, 100% certain, and so on.
Yes.
That's not proper, in my opinion. And in American jurisprudence, when we talk about medical scientific testimony, we talk about reasonable medical scientific certainty,
yes,
or reasonable medical scientific probability, mm-hmm, which literally, figuratively means, more likely than not, 51%. You don't testify, absolutely certain, because, what you're saying is that any other opinion is definitely wrong, and there can be no other possible explanation, and so on. I think that is intellectual arrogance. And if you have a good judge and an attorney who's quick on his feet, he will object to that kind of testimony, and a good judge will admonish that witness not to use that language.
Right. And does it happen sometime that, lawyers have their jobs, the experts have their jobs? I can see a potential clash sometimes. During cross-examination, for instance, does it happen sometimes that as a doctor you feel that you're being mistreated or try to make you mad?
Yes. Oh, you bet your life. You bet your life. In the United States, especially in state courts as opposed to federal courts. In federal courts in the United States, you will find a much higher degree of decorum, a much higher degree of legal propriety, much less in the way of histrionics and theatrical performances and so on. That will not be tolerated in federal courts. In state courts, you'll find a lot of that still happening, and it varies from one judge to another, but you will still find some of that. And the question you asked about lawyers insulting you, challenging you, cross-examining you in a hostile, obnoxious fashion, oh, you bet your life. As a matter of fact, I will tell you that mentally, psychologically, I always prepare myself in advance of testimony for such an approach. Mm-hmm. And if it turns out to be something less, if the other attorney turns out to be, a gentleman and so on, then I consider it, as I say, a good day at the beach. I mean, in other words, so I don't mind. I enjoy probing questions, give and take, and so on. And I do give and acknowledge things. I'm not there to say, this can't be and that's impossible. I just say, in my opinion, such and thus, and so on and so forth. But there are in the United States many attorneys, and you'll find a greater percentage of them among defense attorneys in malpractice cases, among prosecutors in homicide cases, who can become extremely hostile and vicious because they are, so to speak, in the driver's seat. and especially with prosecutors. And what they get away with in the United States, in my opinion, I'm going to be talking about this too. I've talked about it many times in the past years at the American Academy of Forensic Sciences, here at the American College of Legal Medicine, and elsewhere. I pointed out that this is unjust, immoral, irresponsible, improper, unethical, but there's nothing that can be done about it. Usually, you need a strong judge, and you need a strong defense lawyer, attorney, to see to it that these things are challenged and that they are not permitted to go on, unheeded.
Sometimes talking to forensic experts, they would say that it's not just being mistreated that sometimes happens, but sometimes the lawyer has a question that is interesting for him as a lawyer, but it's very hard to answer as an expert. For instance, what is called hypothetical questions. I don't know if you encountered that.
Yes, there's a lot of hypothetical questions, and they're quite acceptable. And it's up to the attorney who has called you to object. You see, you can't object as a witness. You can say, "I don't understand. Would you please repeat that? Would you explain it?" You can do that, but you can't say that's a stupid question, or I can't address hypotheticals. I only deal with reality, or so on. No, you can't do that, because the judge will order you to respond.
So let's say you've seen a case, you examined a body and did a pathology report, and now you're being asked, listen, we know he was dead when you saw him, but let's say he was alive. In that case, what would your opinion be on this and that? Now, you haven't seen him alive, but you're asked a hypothetical question.
Well, again, if the court allows that, your attorney may object. But if the court says, objection overruled, that counsel has a right to pose that hypothetical, then you, as the witness, you must address it. Now, you can say, I agree. You can say, I disagree. You can say, I don't really understand it. You can say that I'm sorry, I don't feel that I'm able to answer that, because you have now created a set of facts that in my specialty I would not address. For example, in what you just said, in your hypothetical example, the lawyer says, well, what if the person was alive, and so on. Yeah. So I might say, well, look, I'm not a treating doctor. I'm a pathologist.
Yes.
And so I really can't tell you what I would have done. And besides, I'm not here, you see, to testify on the standard of care as a surgeon. Mm-hmm. I'm here to testify as a pathologist on what caused the death.
Right. So you work both as a lawyer and a doctor? You also work
as a lawyer? I am a lawyer, and I've done some legal work. I don't have the time to really function as an attorney. For a while, we had a law firm, my son and my wife and I, my oldest son. But my oldest son then became a judge, and so my wife didn't enjoy practicing without him. She now works in my office as my executive person, and so on. But we do some legal things, but we don't handle cases that have to go all the way to trial, and that's strictly by our choice. There would be nothing improper. And in fact, some of my medical legal colleagues in the American College of Legal Medicine, they function half-time as lawyers and half-times as doctors.
Wow.
And that's perfectly fine, as long as you don't get involved in the same case or so on. But there's nothing wrong with that. I just don't have that time. Between the autopsies that I do and the consultations and my teaching and my writing and my lecturing, I just cannot be a trial attorney. I would like to, but I can't.
Health, Ethics, and Law, an online international educational initiative for the benefit of the worldwide public. Produced by the World Association for Medical Law.
So we've been talking for quite a while about expert witnesses and malpractice suits and so on. And there's quite a lot of talk lately in the US about health reform. And I want to connect those two. There's a lot of, I've heard in the last days, a lot of talk about how there is a sense of inefficiency in the system, the way it's working, that you pay the same amount of money that others pay, but you get less health. I don't know if it's true or not, but if it is it related to the...
Well, there are two separate issues. The health issue is not really a matter of legal medicine. The health issue is one which we talk about. We talked about it last night at a dinner among some of the past presidents and so on. And I would agree, by the way, with that observation. And I have some knowledge because I've seen the practice of medicine in Israel. My wife is originally from Norway. I visited relatives of hers there who were in hospitals and so on. And I have knowledge of medical care in other countries in different ways. And I would agree that we are not getting the most for our money in the United States. But those are matters that to some extent might be legal in part, but most of them really have to do with procedural practices, nursing and doctors, and the amounts of money that hospitals are making and pharmaceutical companies are making and so on.
But isn't all this money that is invested in the legal process? For instance, you mentioned cases where it is quite obvious that you should just pay the money and go on.
No, all right, now that's another matter. Now you're talking about medical malpractice. Mm-hmm. Okay, and different systems have been suggested. In fact, one system that has been suggested is the no-fault system. In other words, forget about fault. You have a person who's injured or so on, and let's just take care of it. Right. Then there are modifications on that. Like the doctor, you just say you're sorry, and you work out things, and you pay the patient to take care of their problems and so on. There are systems where you talk about just working things out through panels of other people, physicians who will review matters and so on. And then, of course, the big thing nowadays in many jurisdictions and at the federal level among the conservative Republicans that is being pushed is the cap, the ceiling, that you can only pay X dollars, and it used to be $250,000. Now they are magnanimously raising it to $500,000. Well, I can only speak for myself.
Sure.
If somebody or my family makes me compromised in terms of my cerebral capacity, or causes me to lose a leg so that I can never, bowl or play tennis or dance or ski or run or walk or so on, why should I be limited if there was negligence?
Yes.
Because, and here I'll show you what I consider to be the inequity of that. Because in our country, let's say the same thing happens to you because you're clobbered by a truck driver who was negligent in his driving.
Yeah.
There is no ceiling being proposed for that.
I see what
so let's say you have identical twins. Let's say you and I are identical twins, and we both suffer the very same injury. And you're hit by the truck driver, and I'm damaged by the doctor. You can get $5 million, and I'm limited to $250,000. Where's the justice? Where's the fairness? Where's the morality of that? No, I disagree with the proposed system. And as far as panels are concerned, so 3 other doctors are going to review the case. You talk about subconscious bias. Well, then there again, let me give you the analogy. Why shouldn't you have every motor vehicular accident then? Why shouldn't there be a panel of 3 truck drivers determining whether or not there should be an action? You have an action against an architect, an engineer, a lawyer, or so on. Why shouldn't there be panels of 3 architects or 3 engineers? Why is it so special in medicine? What did God confer upon us as physicians that makes us so special? We should be thankful. Under the Code of Hammurabi, if you did something wrong as a surgeon, you might have your hand cut off. I point that out to my physicians.
Perhaps it's a good idea to reinstate it.
Now you just pay some money, but you can keep your hand.
Right.
No, I don't think that there should be special laws for physicians when it comes to negligence.
Right. So we've discussed several issues, and at the beginning we talked in general about health law and various issues that connect between law and medicine. And from your wide perspective, I would like to ask you a question that I'm asking most of my interviewees. It's a sort of a prophetic question about the future. So if it's all right with you, I would like to meet with you again about 25 or 30 years from now, discuss the past or the next generation. What do you see when you look about health law? What do you anticipate is going to happen in this field in the next 30 years?
I think that we'll have increasing discoveries, first of all, in medicine that will lead to more technological advances and advantages. Mm-hmm. And I think that health will continue to improve. Well, just look, when I was a young person in the United States, as I recall, the expected lifespan was in the mid to late 60s. Mm-hmm. Now it's in the mid to late 70s. a whole additional decade in the couple of generations. So I think people will live longer. Whether it'll be a better life, that's another discussion. I think that there will be more things of a robotic nature, regrettably, less things of a personal nature, and I think that's unfortunate because I think medicine should be, to a great extent, a matter of physician-patient relationship. I think that in the United States, eventually, we're going to move towards health reform measures that will make us more in line with what you find in Israel, in Western European nations, that in our country, the Republican conservatives love to refer to as socialism, suggesting that socialism is really communism.
A scary word, right?
Oh yes. In fact, some of the ultra right-wing people, Rush Limbaugh and Glenn Beck and that crowd, they definitely equate socialism with communism and so on, and that is so rotten, so evil. But that's a political discussion for another day too.
Yeah.
But getting back to your question, I think that overall things will improve in terms of overall health care, but I think that there will be a diminution of the personal relationship that is so important in medicine, and that is regrettable.
So that's what you anticipate in medicine. Now, when we talk about health law, we're talking about how the law is, looking at medicine. Do you think those changes in medicine will have some impact on the relevant laws or case law?
I think as we develop more and more technological advancements, there will be more and more statutory law in the United States, both by the federal government and by our 50 states, to deal with a variety of things. Some of these will be for the better, and some perhaps not so. But I do think that there will be more intrusion of the law rather than less as we move ahead. Because the more things become laid out technologically, the more things move away from human touch and potential human error, the more are they susceptible to objective analysis. And therefore, you can theorize, if that be the case, then is it not easier to analyze and to appraise these situations in order to ascertain if something was done improperly or incorrectly?
Yes, but that can be done, I guess, with what we have today, isn't it?
Oh, yes, to some extent, but I think that that's going to increase. Yes. And I'm glad I won't be around for that. I'm glad that in my field, not that I enjoy dissecting bodies. I mean, I think of every person as a human being, and I always think of that person and her family, and so on. But what I like about my field is that it's me doing an autopsy. It's not a robot.
Right.
I'm doing the autopsy. I'm dissecting the body. I'm examining the organs and the tissues. I'm looking at them microscopically. I'm expressing my opinion. I'm correlating those findings with the clinical record and so on. In various areas of medicine now, so much of it is robotic.
So the human touch is gradually...
Oh, definitely. I remember as a kid, doctors came to my home. I had a bad cold. I was sick. My mother called up. And I remember that wonderful doctor. He was a Jewish emigre from Russia and practicing in the United States. And he came to my home and examined me as a kid. There are no more home visits in the United States of America unless you're maybe a multi-millionaire and you can have your own physician. And sometimes that's not so good, as we recently witnessed with Michael Jackson. He had his own home care physician who's now charged with murder.
Dr. Wecht, thank you very much.
Thank you. I hope that we shall talk again.
This was another program on health, ethics, and law, an international educational initiative of the World Association for Medical Law. Scientific advisor, Professor Thomas Noguchi. Editing and broadcasting, Oren Asman. The program is available at www.wamlradio.org.